Thank you. Good afternoon. Our first case today is 831551, In Re Dependency of PS. And would petitioner like to reserve time for rebuttal?
Yes, Your Honor, 3 minutes, please.
Okay, go ahead.
Good afternoon, Your Honor. May it please the court. My name is Jennifer Swigert, and I represent the appellant mother in this case, referred to by her initials, CG. We're seeking this court's discretionary review under RAP 2.3b2 of the decision removing CG's daughter from her care and changing the permanency plan to adoption. The children were returned home in November 2020, and the department's motion to remove them was denied in July of the following year, but then granted in early September. This decision was probable error that substantially altered the status quo. Turning first to the probable error prong, the court committed probable error in removing the children without sufficiently changed circumstances or a valid reason for removal, such as a manifest danger of serious abuse or neglect.
Can we talk about the language of the order? Because the order where it's just the one child, or is it all the children? What matters is P, correct?
Correct.
So when P was returned to home, that order is the January 11th, 2021 order?
Yes, I believe that was when the official order was entered, yes.
And so it does actually say in the order, so this is page 234 in the appendix, 235. It says in the order it's a trial return home, and it's conditional. And then as respondent points out, the statute, RCW 1334-138-3, appears to indicate that the child may be removed, upon, that the placement is contingent upon the compliance of the parents with court orders. That sounds different than the test that you were talking about in your brief, and I think that you're talking about right now, which is you have to have a change in circumstances.
Well, we don't dispute that that is in fact what the order says,
Okay.
or that is what RCW 1334-138 says.
Yeah.
Our argument is that we have to harmonize this with other applicable law that also pertains in this situation. So before the court can order the children returned home, and this is also under 1334-138, the court has to find that no reason for removal, that a reason for removal no longer exists. So we know that back in January when the court entered that order, the court was expressly finding that there was no reason to remove these children from their parents. And so under those circumstances, it simply doesn't make sense to find that you can disrupt the child's sense of stability. And we know that how paramount the stability of placements is for children. It just makes no sense to say that we can just yank the children out of this stable placement anytime the parent fails to comply with any aspect of the case plan or the service plan. And so then we have to look at 1334-150, which says that no dependency order can be modified without a showing of a change in circumstance.
So, but when I read the transcript of the July hearing, I saw in the hearing transcript that the judge said, I'm going to deny the request for removal. But he also said a lot of other things about how, the parents were not meeting the conditions, not following the orders, and he wanted that to be addressed immediately, right? And so he talked about some stability, but said that there were things going on, including a very recent police report, correct?
Yes, Your Honor.
So what I'm concerned about is I understand that it was denied. I mean, the removal was denied. But the trial court said a lot of things during that hearing indicating he was giving a last chance. So can you sort of tell me about that?
If the judge had honestly believed that the circumstances were so dangerous that removal of the children from a stable placement was required, I don't think we can say that the judge would have hesitated to do that in July. Mm-hmm. So instead, what we know is that in July, the judge was clearly frustrated with the lack of compliance by the parents, mm-hmm. but was not finding that that amounted to a danger to these children, mm-hmm. Certainly not the manifest the clear, cogent, and convincing evidence of a manifest danger of serious abuse or neglect, which would be required to place the children out of the home. And so our argument is that we know that the court found there was no reason to remove them from their home in January, when the children were officially returned home by court order. And we know that in order to change that, we need to have a finding of a change in circumstances. So the question is, what needs to change about the circumstances to justify removing these children? And the logical answer to that question is, well, there needs to be a new reason to remove them. And when we go back to the statute, the state is correct that there are 3 possible reasons for removing children from their parents' care during the dependency, but the first 2 of them can't possibly apply. The first one is that the parent is not available. That's not true. P has 2 parents who are available. The second one is that the parent's not willing to take custody of the child. Again, also not true here. Both parents are disputing custody. And the third one is clear, cogent, and convincing evidence of a manifest danger of serious abuse or neglect. And so if we don't have that, it's simply not sufficient to justify disrupting this child's stable placement. And the court was looking at several different issues, but again, so taking, for example, first the evidence of the parent's drug use. To the extent that the state may be arguing that that constitutes a manifest danger of serious abuse or neglect, that doesn't appear to be true, because if that were true, steps would have been taken long before September. This was not a changed circumstance. The social worker's declaration, and that's at Clerk's Papers 144, the mother reported a relapse in March, and the children weren't removed until September. In May, the mother had a new drug and alcohol evaluation that recommended detox and inpatient treatment. So we had several different signs that there was some drug abuse going on here, but no one thought that amounted to a manifest danger of abuse, obviously, because they didn't try to remove the children for months after that. The same is true with the lack of background checks. They didn't have the background checks from the very beginning. The same is true with the school attendance issue, and that makes even less sense because what we have was the first sort of 6 months or so of the in-home placement, we had issues with attendance, and then in July, the court said, no, that's not enough to find, I'm going to remove her right now. And then in September, when the school year had barely started, so we have no way of knowing what her attendance is like, then suddenly we're removing. So I'll reserve the remainder of my time for rebuttal, but we would ask the court to grant review and reverse.
Thank you. Respondent?
May it please the court, my name is Usam Ahmed. I'm an Assistant Attorney General representing the State of Washington Department of Children, Youth, and Families in this matter. The department requests that this court find that the mother has not shown probable error and deny the motion for discretionary review for 3 primary reasons. First, consistent with statute, the juvenile court properly exercised its discretion in removing PS. Second, the court considered the evidence, allowed the parents to address the allegations against them prior to removing PS, and no party raised an issue regarding the appearance of fairness during the proceeding. Finally, substantial evidence supports the finding that in this nearly 4-year-old dependency case, the reasonable efforts to prevent or eliminate the need for removal had been made. At the onset, I will also provide an update as to this case. As of May 2022, PS was returned to her parents' care for a trial return home, and that is currently where she resides. The department would argue that that renders this case moot, but I will still address the underlying arguments. Turning to the issue of removal, when a statute is plain on its face, the court must give effect to that meaning. Here we have 2 statutes, 2 provisions in the statute. The first is regarding the change of circumstances. A comparison between the orders in July and the hearing after that does demonstrate a change of circumstances in this case. In the July hearing, the court found that there was, for the first time, a sense of stability in the home. And then in the next hearing, the court found that there was chaos in the home or no stability in the home. The court ordered the mother and father to undergo random urinalysis testing at the July hearing, the results of which were positive UAs. As noted in the department's responsive pleading to the father in the underlying matter, and as identified by the court on RP 10, when the father's attorney counseled argued that there were no changed circumstances, the court interjected and asked, other than the father's methamphetamine use. That's on RP 10. The father was provided an opportunity to address that specific allegation, which had remained unaddressed in his multiple pleadings. The other issue was that, as Your Honor had just pointed out, the court did lay out certain conditions for both the department and the parents at that hearing. The court expected to get into compliance with her drug and alcohol treatment. At the next hearing, the mother began arguing that she was not court-ordered to engage in any sort of alcohol treatment, drug and alcohol treatment, rather just complete an evaluation.
I'm not exactly clear, are you agreeing with the petitioner that RCW 1334-150 requires a change of circumstances before removing during a trial home?
It requires a change in circumstances to modify, set aside, or change a dependency order. I think it's broader than just placement. But in this case, the noncompliance is a change of circumstance, and certainly the father's positive UA, the first UA he had done since PS had been returned to their care for a trial return home, does constitute changed circumstances.
So under 3A, 1 and 2 of 1334-138, the idea would be, in these particular circumstances, a lack of compliance with court orders would satisfy the 150 requirement.
Yes, and the statute 138, which I'll turn to, is very clear on its face. It says that in-home placement is contingent upon compliance of the parents with court orders related to the care and supervision of the child, and continued participation of the parents in available substance use treatment or mental health treatment, if those are contributing factors to the removal. It specifically in 3B outlines a removal process. I would also note that the removal process allows for the department to unilaterally remove the child, subject to court review. In this case, the court was the one that removed the child and made that finding. That statute in particular highlights that noncompliance with the case plan or court order, inability, unwillingness, failure to participate, or failure to successfully and substantially complete available services by themselves, by the parents themselves, or for the child, including substance use if that was a contributing factor to the abuse or neglect, could constitute a grounds for removal. In this case, there was clearly noncompliance. By that second hearing where there was a removal, there was arguably unwillingness by the mother to engage in substance use treatment. PS had not engaged in the court-ordered counseling by that point either. The statute is unambiguous in its reading, and in the absence of any sort of express case law or statutory reference, the mother argues for a need for a finding of manifest error, which comes from that dispositional statute, RCW 1334-130, subsection 6. As the mother had noted, there are three prongs: the no parent available, the parent not being willing to take custody, or that manifest error. I would note that with respect to no parent available, In re WWS does elaborate that available is beyond just physically available. It refers to the ability to safely parent. I would ask that this court reject the mother's argument to read into the statute a new requirement that on its face is unambiguous. I believe the changed circumstances have also been highlighted, so I want to turn to the argument regarding bias and appearance of fairness. The Supreme Court case Caperton outlines the situations in which bias may be found. It's a limited set of circumstances, none of which are present here. They include having a financial interest in the outcome of the case, or the judge having previously participated in a case in an investigative or prosecutorial capacity, involvement in a critical decision-making role regarding the defendant's case as a prosecutor, and then finally having some individual having a stake with a case had a significant and disproportionate role in placing a judge on that case through the campaign process. There's nothing in the record, or as far as I can tell, argued that one of those applies. With respect to the appearance of fairness, that's not a constitutional issue as outlined in State v. Morganson. Under RAP 2.5A3, it may not be raised for the first time on appeal, and there's nothing in the underlying record that raises that issue. Judges are presumed to be they're presumed to be honest, and there's a presumption of integrity afforded to decision makers that the mother fails to rebut. Had this issue been raised properly in the underlying case, the mother would still fail because dependency proceedings, at the onset, this was a very contested remote hearing. Hearing regarding a removal is never going to be easy, but this is the same judge that had just previously denied the department's motion to remove. This is the same judge who had been on this case since PS was returned home. There's a certain uniqueness in dependency cases where there's a familiarity between the judge with the facts and the parties, as well as the purpose of these proceedings being rehabilitative, to restore, to bring the parents back to a trial return home and ultimately have that case dismissed with a return home. In that contested and emotionally charged hearing, the parents made some misrepresentations that further escalated the situation. As I indicated, the mother argued that she was not court-ordered to engage in treatment. The father at one point argued that the mother had passed all her UAs. And at one point even he was asked by his attorney to stop talking, yet he continued to talk. And it was sort of after all that the judge finally did exercise his discretion in managing his courtroom to mute him or to have him muted. It's really the parents' failure to engage in services and to be in compliance with their services over, at least from that post-July period and really throughout the entire trial return home, that warranted the need for removal. And since I do have some time, I would just briefly address the efforts that were made in this case. Given the fact that this was a trial return home, obviously someone had done something right to bring the parents to the point where PS and at that point her siblings could be safely returned to their care under the care of the supervision of the department. The child always remained under the care and supervision of the department. Even that January order gave the supervisory role to the department. And the child was never outside the supervision of the department throughout those nearly 6 months. There were efforts made to get mother into dual diagnoses programs, which was highlighted by her brief. There was Square One that she had previously been participating in, where she went back for an updated assessment. There was later Valley Cities, which she went to, and then the referral was provided for the father to get both an evaluation of mental health and substance abuse. And then the in-home services that were ordered were also placed there. So I do believe that the department fulfilled its obligation in providing reasonable efforts to prevent or eliminate the need for removal. I would ask the court to deny this motion for discretionary review as the statute is plain on its face. Thank you.
And petitioner, 3 minutes for rebuttal.
Thank you, Your Honor. Just a couple of brief points in rebuttal, a few. First, the removal from the home is not a moot issue despite the interim return of the child. This spending 9 months out of her parents' care is the type of thing that the court may rely on in future proceedings, so long as the dependency continues and there's the threat of a termination case ensuing. This is not something that can be moot. And then I want to turn to the question of the substantial harm that's caused when children are bounced from one placement to another. There's quite a bit of research in case law documenting the harm of having children be in multiple placements. And so given that harm and the absolute need for stable placements for children when possible, the mere failure to comply with any aspect of the service plan simply can't be a valid basis for disrupting that stability. And so we again argue that we have to harmonize all the statutes and all the principles at issue here. And under those statutes, the court committed probable error in removing the child without a manifest danger. And the fact that the child was then returned back to the parents again 9 months later actually only supports the idea that this was probable error.
Can I just get you to comment? I'm concerned about requiring some additional finding under 1334-150 when 1334-138 actually says home placement shall be contingent upon the following. I'm not sure what that means if it's not actually contingent on those. Do you understand what I'm saying?
Yes, Your Honor. But the fact of the matter is 1334-150 also directly applies. That is a dependency order. That is an order entered in a dependency case.
But if it's something that's listed as a contingency, it can't satisfy 150?
Well, the statute lists as contingencies basically all compliance with the case plan and the service plan. And so if we're going to take that literally, then basically the stability of any in-home placement is completely illusory, because the slightest misstep by the parent can be justification for yanking those children out, disrupting their stability, causing major upheaval in their lives. And that is simply not what is intended when we know that the purpose of this is remedial and is to do what's in the best interests of the children. That's the paramount consideration in all of these child welfare proceedings, is the best interest of the children. And we know that placement after placement after placement and repeated upheavals are not in the best interests of any child. And so when we try to harmonize all of that, we argue this is probable error that substantially altered the status quo. We ask the court to reverse. Thank you.
Thank you for your argument. Thank you both for your briefing and your argument. It was helpful, and I will issue a written ruling. This concludes our hearing. Thank you.